Hello, and welcome back to the Master Academy Law Club YouTube channel. This is the video on the Federal Rules of Evidence and Procedure. Make sure to check out our previous video, which will be in the top right-hand corner. Since 1975, all federal courts have adopted a standard set of rules called the Federal Rules of Evidence. Trial judges use these to control the admission of evidence, and when a judge's decision is appealed, it is generally upheld. In some situations, when a judge has determined that significant prejudice has occurred, the judge will declare a mistrial. The hearsay evidence rule states that witness testimony not based on their own knowledge is not admissible. This helps to exclude highly unreliable evidence from being considered. This rule also guarantees the opposing party a chance to cross-examine the person who said the statement. There are many exceptions to the rule, such as the spontaneous declaration exception. The general rule is that when someone can give relevant information, they should testify. However, there are certain types of privileges that individuals are entitled to. Where a privilege exists, the person benefited by the privilege, the holder, is entitled to refuse to testify or to block a person from testifying. The marital testimonial privilege permits one spouse not to testify against the other in a criminal case. The marital communications privilege permits the spouse from testifying about a conversation between the two spouses. The doctor-patient privilege stops doctors from testifying about information used for the treatment of a patient. The attorney-client privilege stops attorneys from testifying about conversations or work done for the clients. Evidence, no matter the type, must only be admitted if it is relevant. That is, the evidence must logically prove or disprove some issue of the case. Probative evidence tends to prove something of importance to the case. Relevant material that has significant probative value is material. Anything that is irrelevant or immaterial should not be included in the court. Evidence must be competent or legally admissible. To be competent, witnesses must take an oath to affirm they are telling the truth. When special expertise is needed to solve a factual dispute, the jury is not competent to solve that dispute, so the court calls an expert witness. Expert witnesses are people with special training or knowledge that enables them to solve disputes. The best evidence rule states that unless original documents are unobtainable, original documents should be used rather than copies. Second-hand copies are only admissible in court if the loss of original documents is not the fault of the party seeking to introduce them. By watching this video, you are supporting the Master Academy Law Club. The Master Academy Law Club is a student-run organization that aims to give everyone a fair shot at learning the law. Make sure to like the video and subscribe for future videos. More court videos are coming out soon. Share the video with anyone who may need help on the topic.